Welcome to another episode of Tanstwocents podcast. Today's episode is titled Government Contracting at the Crossroads. We're going to unpack some of the most pressing issues in GovCon litigation and protest, from AI to GAO to stalled termination settlement proposals. I'm your host, Tanwilson, and today with us is David Timm, Senior Associate at Burr and Forman, LLP, and he represents contractors in disputes, claims, and protests across GAO, U.S. Court of Federal Claims, and the Board of Contract Appeals. Dave is the chair of the Bid Protest Committee for the Federal Bar Association and writes and speaks frequently on GovCon legal issues. And if you're not following him on LinkedIn, you are missing a really great conversation. David, thanks for joining us here today, and say hello to our listeners, the Intellectuals, and tell them a little bit about yourself.
Yeah, thank you so much, Atan, for having me on. I really appreciate the opportunity. I really like talking about GovCon issues. I guess I'm a little bit nerdy that way, and so my story with government contracts goes back to law school, where I went to GW, and as you probably know, they have a very good procurement program at the law school, and so I knew I wanted to do litigation, and government contracts seemed like a natural fit, and so I've been in the practice of government contracts for my entire career, including during law school when I did an internship for the Transportation Security Administration Office, and also for my first job as a summer associate.
Okay, that's great. And are you local to like the DMV area?
Yeah, I live in Arlington, Virginia, just over the bridge from DC, where our office is.
Yeah. Well, I'm starting to collect attorneys, so we'll have to have like battle of the law schools someday.
Well,
That'll be fun.
luckily, in the DC area, at least, if you throw a stone, you'll hit an attorney. So there's no shortage, that's for sure.
Isn't that the truth? But that's okay. We like attorneys here at Tanstwocents. So before we dive into some really important points and topics here, I know that you've handled cases at the GAO, the Court of Federal Claims, and others. And if you had to compare the protest at the agency, GAO, and the court level to, let's say, a baseball league, who would they be and why?
Yeah. So the way I always talk to clients about the three forums, and when you're doing a bid protest, you basically have the choice for a federal protest of going to the agency itself,
Mhm.
which where it's reviewed at a level above the contracting officer, or to the Government Accountability Office or GAO, or to the Court of Federal Claims. And so I think they're sort of in that order. I go, the agency is sort of like Little League. You know, and I think people intuitively understand
Yeah.
why that's the case. While it's not the contracting officer who's in charge of the procurement directly reviewing the protest, it's still someone who's in the agency itself. And as you can probably guess, and most people intuit, you're not going to get quite the independent, critical review that you would at another forum. So up from there, you get into GAO, which I sort of view as the minor leagues. And again, good place to take bid protests. It is an independent agency, so if you've got a contract with the U.S. Army, for instance, GAO is a separate agency. The individuals are different, and the folks who are reviewing the bid protests are attorneys whose job it is to just do that. So those are some of the benefits. Along with those, I think it probably is similarly inexpensive compared to an agency protest. The
Right.
filings aren't as complicated, and the review is statutory in that it has to be finished within 100 days. So, along with that, you get the Competition and Contracting Act automatic stay of contract award. So until the bid protest is resolved, the whole process grinds to a halt until they've completed their review. So while I like GAO a lot, I think that they're not as deferential as the agency itself, but they tend to be pretty deferential to the decisions that the procuring agency is undertaking. And so that brings us to the major leagues, and that's the big show. That's the Court of Federal Claims, and it's the same sort of idea, right? You have a court
Yeah.
now, so filings are more complicated. There's more briefing. Sometimes there's oral argument, where there's very rarely oral argument at the Government Accountability Office. There's also expanded discovery, it can be very important. I've had a case where we lost at GAO and then appealed it to the Court of Federal Claims. And really, the only difference between the two results, we lost and won, was that we got more discovery that the agency hadn't previously released. And so that's a very important consideration. Of course, all of these benefits
Yep.
come with at least some sort of balancing factor, and that usually is the cost to litigate is higher.
Yeah. I like that. So for all the baseball fans, because it is baseball season, right? I had to throw a softball your way to like start. Yeah, my kid made it up to to kid pitch in little league, so it's been a while since I've had to sit through a baseball game. So not a big baseball fan here, but I know our listeners are, so I figure I'd toss that out. But that was a really good explanation of the different levels, and I think that's a really great foundation for us to have the rest of our conversation. So I think I'd like to dive in a little bit more with our first segment, which is, this growing divide between the GAO and the Court of Federal Claims. And we'll see throughout this conversation which one I kind of prefer. So I do have a bias towards one, bias of the other, but it's not always steadfast. Like you said, it really kind of depends on a lot of different, factors as to which way you should go. So let's start with this tension, so should we say, between GAO and the Court of Federal Claims. And we've seen splits in some outcomes. Sometimes the same issues are decided differently depending upon the forum. So why does this happen, and what should contractors consider before filing? Because you would think if you're going in with the same argument for the same situation, that both entities should come out with the same ruling, and they don't. So riddle me this, Batman. Why is this?
Yeah, that's a good summary. They really are reviewing the same regulations and rules, right? Typically the federal acquisition regulation is what the court or the GAO is reviewing when they're looking at a bid protest to determine whether or not the agency's made a mistake, right? And so you would expect, a reasonable person, I think, would reasonably expect that they would come to the same conclusions, and that's just not the case. For those who want it simplified, the Court of Federal Claims is better on all issues for contractors compared to GAO. That's the simple answer. And there are a number of issues, and I've written about some of them. I published about some of them, and I talk about them fairly frequently. Thank you for the shout out on LinkedIn. I like writing on there and engaging in a conversation with so many people who are touching the bid process and the contracting process. So yeah, I've written about this before. One of the biggest issues is the key personnel change issue. So the two forums, they disagree about whether contractors have this duty to notify the procuring agency of a change in key personnel. So, you're submitting for a services contract, and your key personnel becomes unavailable before the award is made. If you go to GAO, they're going to say that the offeror was required to make the procuring agency aware that the key personnel changed after proposal submission. On the exact same issue, the Court of Federal Claims has held repeatedly that offerors aren't required to update the government when their personnel becomes unavailable. So, a couple cases for the nerds who like to dig in. You have Golden IT versus United States. That's a 2022 case. Court of Federal Claims just said all the contractor has to have is a reasonable belief that the key personnel would be available at the time of its quote, right?
Yeah.
So, but you compare that with numerous cases at the Government Accountability Office, for instance, Greenleaf Construction, which is the 2006 case, or a more recent one from 2020 called NCI Information Systems. And so, GAO says even if the contractor lacks knowledge about whether the key personnel will be available, the contractor is obligated to notify the agency. So, there are a number of issues like this. A couple others. I'm not sure if folks will be overly familiar with what a wedding signature is anymore
A
these
wet
days on a
signature?
bid bond.
Okay. A wet signature?
Yeah, a
Yeah.
wet ink signature.
Yeah.
Yeah, as opposed to like a digital signature. And, so I actually litigated a case with two of my colleagues, Dirk Hare and Joe Cohen in 2023. And in that case, it was called Togiak Management Services. The decision looked at this issue about whether a wet ink signature or a digital signature or photocopied was acceptable for a bid bond. And the these two forums, they look at each other and each other's precedent, and they acknowledge that it can be persuasive, but they're not bound by it,
Yeah.
right? In the typical way where, like, for instance, if the Federal Circuit, which is at a level above the Court of Federal Claims, says something, they come to a decision on a topic, Court of
Then
Federal
that's
Claims, yeah, exactly. They have to follow that. It doesn't matter. But because they're two unrelated forums, they just consider each other persuasive. So in this Togiak case, it was really interesting because the Court of Federal Claims, and this goes to what I was talking about earlier, the major leagues versus the minor leagues concept. The Court of Federal Claims, the court in that case, they looked at the GAO case that the procuring agency had relied on for the proposition that only a wedding signature was good enough, and they said that the GAO was misinterpreting its own precedent in coming to that conclusion. Basically, they had kept extrapolating through a line of cases and slightly like getting this
yeah.
drift in how the decisions were being made about what was acceptable. Because there is a concern if you don't have a wedding signature that there could be some sort of fraud that's
Right.
impactful. Anyway, so that's one that's really in your face, right? It's very clear that the two forums disagree with each other.
Yeah.
There are others where they touch the same topic, but they don't necessarily come out and say it. Oh, we just totally disagree. And there are still a few other issues, but you could go down this path for hours.
Oh, yeah. No, seriously. And I think the example that you highlighted is a very common issue with key personnel. And I do take exception to, the requirement of key personnel, just because some of these opportunities are in source selection for months, if not years. I'm sorry, like I'm going to hold a contingent hire, or I'm going to keep someone from, being put on another bid or another contract while you government try to uncork yourself. So, the timeliness of the notification, the when you notify, it is so sticky. And so, I think so long as the offer comes in with a good faith effort that, this is, who we are planning on using. I think then, that's on the government then when that person doesn't become available. So, um,
Yeah.
anyway.
Yeah, that's a great point from the proposal perspective, right? I'm always coming at things, trying to figure out, what's going to be most helpful for the client. And, looking around corners is one of the things that I like to do. It's one of the reasons that I write on LinkedIn and I publish and speak because, part of it's sort of the networking, relationship building thing. And part of it is just for me, right? I'm writing to stay abreast of the most recent changes, and there are a lot of those, as I'm sure you're aware, especially recently.
Yep, no, absolutely. So I think this really dovetails nicely into our next segment about timeliness in GovCon. Late is late, right? And there's a lot of talk about timeliness, and it's critical, especially when you're submitting a proposal, but it's so much trickier and so critical when you're trying to file a protest. And so I think the challenge is calculating timeliness is not always straightforward. You know this, I know this, but trying to explain and walk a potential client who might be thinking about protesting is really kind of challenging. So, when does the clock really start? And is it from, the moment an offer learns about an issue, or from when the agency formally notifies you? There's so many different ones regarding, whether or not you're going to file through GAO, through the agency, through the court. So kind of unpack that a little bit, and kind of walk us through maybe highlighting some gray areas that, may be a little unclear to a potential client.
Yeah, timeliness for filing a bid protest is a really interesting issue, and that the rules are different for GAO and for the Court of Federal Claims. In essence, and this goes again once more to my framework of the major leagues versus the minor leagues, and Court of Federal Claims being more favorable to protesters than GAO. At the Court of Federal Claims, you don't have like a certain number of days to file a bid protest, and that's in stark contrast to the GAO, where it's usually either 10 days from when you knew or should have known, or 5 days after a required debriefing. There are lots of nuances with how that can be applied, and I'll talk about a couple of them. But Court of Federal Claims doesn't say 10 days or 5 days, depending on the debriefing. The test there is really this question of, has the contractor sat on his hands and waited, beyond what's reasonable to protect their rights? And, one of the big principles, and one of the reasons that GAO's timeliness requirements are so strict is that we don't want to delay procurements unnecessarily. I'm sure many people in your audience have been on the other side of a protest where they're the awardee, and then they see a protest come in and they don't get the notice to proceed. Yeah, and they, it's a very frustrating process from that perspective. And that's why GAO has such strict timeliness requirements. And what I say is, if you are, if that's sort of the tiebreaker, if you're just past 10 days, for instance, at GAO, there's no sense in throwing good money after bad. And unfortunately, a lot of times clients come to us and they say, "Hey, we think something smells here. Can you take a look at it?" And it's due the next day. Uh, it's understandable because it's always tight turnarounds, and
Yeah.
clients have lots of considerations to take into account. Often, a lot of times with complex bids and subcontractors or teaming partners, there's multiple sign-offs they need to get. But that's why I think that it can be useful just to have somebody on speed dial right
Yeah.
when you get the award notification, and then potentially you can involve them with the debriefing process. I love writing questions for a client to ask during a debriefing, whether it's written or oral, so that they can really get to hopefully the nub of the issue about why they lost, or whether there's a protestable legal question, in what the agency did. But I think generally the way to think about it is that if you knew or should have known, then you've got 10 days. And the intervening, contingent factor there is whether you've requested a timely required debriefing.
Yeah.
So that's sort of the lay of the land there.
So I think from a timeliness perspective, that's why um, the one approach to pre-award protest is
Mm,
so infrequently discussed, or and a lot of clients aren't even aware about that, right?
yeah.
So I find a lot of times they'll submit the proposal, they'll get the unsuccessful award letter, and then they'll complain about
Hmm.
something that they knew when they submitted the proposal. They knew when the Q&As came out,
Yeah.
and they, like you said, they sat on it, hope
Hmm.
the outcome would be different, or
Right.
hope that, someone else will either ask the question or protest or whatever. And then they don't. And then they're like, I call that the sour grapes protest.
Yes.
And so because of the sour grapes, we're going to protest. And it's like, you relinquish your rights to doing
Mhm.
that because of that timeliness um, requirement.
Yeah, I really like the way that you put it, sour grapes. A lot of times bid protests can be very emotional, right? If it's a big award, it's really important to your company. So I totally understand that emotion gets involved. But what I do tell people is that when clients come to me and they say, "Hey, we lost, and we think that something hinky went down with the award," uh, I often go through the analysis of whether they've got a
Yeah.
shot or not, and I try to give them like a reasonable assessment of their odds of success. And then I think probably 8 or 9 times out of 10, I tell them, "Hey, save your money for the next bid. Like, don't throw good money after bad. That's an iron law in contracting." Um, and there's so many different ways that your case can not be viable, right? Like you mentioned
Yeah.
one before, if you've sat on your hands, you didn't file a pre-bid, protest or properly go through the RFI and Q&A procedures to clarify, a really material point for pricing, or whether there's actually key personnel required, or whether the contract should be set aside for a small business or the 8A program. Those are, I think that people think of the bid protest process as very, very contentious. And they're worried, this is their customer. They don't
Yeah.
want to tick off their customer by bringing a protest. I think once you've exhausted the RFI process, the Q&A process, you should strongly consider what I think is the least aggressive type of protest. If there's something in the solicitation that you take issue with, any of those things that I just mentioned, or even the NAICS code, right? You can bring that, and because it's not going to be, there isn't already an apparent awardee who
Right.
will intervene and fight you on it. The agency hasn't already made its decision. Those sorts of protests can be uh, can result in a win-win for both the
Yeah.
agency and for the contractor, because what you're doing is you're saying, "Hey, I see a problem here. I think that you can fix it, and here's how you can do it." And the main trick with that is the framing in the protest itself. You can make it using non-aggressive language
Mhm.
and ensure that you're not coming down on the agency for doing something wrong. You're just trying to get to the right place.
Yeah. And I would say that this is really kind of one of those really good opportunities for you to practice tone with
Mm.
your ChatGTP, right? I think that's one of the things that AI is really good for is I will take a really harsh stance on something and ask it and tell it, soften my tone. I want to be firm. I want to be very transparent. I want to be very clear. However, I'll tell it to say it in a kinder way or say it in a very objective kind of way. And it can really kind of help you reframe and reposition because tone and context matter,
Yeah.
especially when you're working with the government. And I think if you approach it, like you say, in a very contentious us versus them type of,
Mhm.
approach, you're not going to get the same outcome as if you were to approach it in a, hey, I'm doing this to help you, like help me to help you approach.
Yeah, and I don't think a lot of these sorts of protests get discussed much in the in the GovCon community. Oftentimes, if you see someone on LinkedIn, and I do this, I'll put the PDF of a decision for a GAO protest, and I'll say, here's a takeaway from from what happened here. When you get a public decision, you need to back up and understand how the process works at GAO. So if there's a problem with the procurement, um, and the agency recognizes it, they have carte blanche to take corrective action and resolve it without needing to go through the whole contentious litigation process, right? So let's say that you file a protest because you were excluded from the competitive range. In a situation like that, we've had a lot of success, especially over the last couple of months. Partner I work with, Sean Milani, and I have resolved a bunch through corrective action where we didn't say, hey, agency, you're such a bad, agency, and you did X, Y, and Z wrong, and you're so terrible. No, it was more like, hey, you interpreted the requirements like this, and actually, we think we complied with them based on the plain text of what the solicitation asked for. And so what we're asking for is that you re-include us in the competitive range. And guess what? In a lot of those cases, the agency wants to take corrective action. They'd like the most competition possible.
Wow.
Maybe your offer was the low bid, or it was going to be the low bid, and now they have a better way of meeting their own budget.
Yeah, that's that's a bit of like hot news there. That I don't think that I've thought about, that I think our intellectuals will really appreciate. So, intellectuals, take note here and contact David and have further discussions on that, because there's a lot of multi-phase type of bids out there that some people just kind of walk away and call it a day. So, if you know that you need to
And we're
want
seeing
to stay in the fight, then stay in the fight.
exactly, yeah, excuse me. We're seeing a lot of those sorts of protests recently, where it's a little bit of this like ticky tacky.
Yeah,
They would say something like, "You didn't acknowledge, the amendment," right? Something like that. And it's you have to do the analysis up front and the precedent and make sure that you've got a good argument. But then you can go in, there's a specific FAR clause related to minor informalities, in bids.
yeah,
And if a agency has eliminated you on that basis, I just think like people take it very personally when they either don't win or when they're eliminated from the competition. And you need to think about it from their perspective, especially in light of the changes over 2025. These agencies are understaffed. They're really trying to do the best they can for their for their projects, and they're not always getting your perspective. And a protest can be a way of sharing, hey, this is
yeah.
our perspective. And if they take corrective action, great, then all of a sudden you're back in.
Yeah, the minor info, that minor clause, I've
Mm-hmm.
used that before too, because we've had a client that was excluded because the font size
Yeah.
was wrong or too small in the footer. And so it's like, wait, it's the footer. It had
Mhm.
no material, and it was half, it was one of those random one page type of thing. And we argued it. They conceded and said, okay, yes, we'll put you back in. But normally I'm a very big, tic tacky, like I'm one of those very particular type of people about things like that. And I'm like, yes, toss them out because I need one less person there to compete against me. So I'm all for those um, easy, low hanging fruit type of dismissals. So we
Yeah.
could literally talk about this topic for like hours, but I think I started down the path of AI here. You can't have a discussion nowadays without talking about AI. So let's roll into our next segment about AI misuses at the GAO. And you've written
Yeah.
about
So,
this before.
I wrote about this issue in August for the first time And when I published in earlier mid-August, there were 4 decisions that were public at the Government Accountability Office, where GAO mentioned in the decision specifically that the protester had used some form of large language models, or LLMs, or what people commonly refer to as artificial intelligence, to draft their bid protest. And in all of the cases so far, and now there are 7 published since
Oh, wow.
as of today. I think that and these just started cropping up in May, right? So we've already got 7. All of them are pro se protesters so far. So that means that they're protesting without the aid of legal counsel.
Okay.
And so, typically courts and the GAO will treat pro se protesters a little bit more gently than they would an attorney, uh, for making the same sort of error.
Right.
Yeah, there's a connection I have who runs what is like a database of all of the legal issues with AI related sanctions, not just in the United States but throughout the world. And I think since 2023, we're like around 400 that have been noted and collected and put into the database. And this is his side project, so he's not exactly scanning every docket.
Oh my God, I want to see that so badly.
Yeah, I'm happy to share a link, and we can put it in the description for the viewers later.
Oh, that would be fit. Great.
Yeah. So at GAO, what we're seeing is that all of these protests have been denied, but not because of the AI misuse yet. So every time GAO has discussed it, they've essentially done it sort of as a warning, right? And the way I think of it is they're trying to warn the overall government contracts community. Hey, if you're using AI, it can make some errors that will end up in your bid protest and could cost you. And the reasons are pretty easy to understand. So the things that GAO and other courts have been focused on are fabricated or inaccurate citations to legal authorities. And basically what that means is the LLM will tell you, hey, here's a great case that supports your position.
It's done some
And
creative writing.
yeah. And it will either be something that is completely made up from whole cloth, just not at all related to a case that's real, or it'll have problems with the citation itself. For instance, it'll use a different case number, or perhaps the worst of all, it'll be a real citation, but it'll say, that it said a specific thing.
That
And then when you read the case, it didn't say anything like that. So, these problems are, I think people are starting to understand that large language models have the capacity to do this thing called hallucinating, which is just sort of a fancy term for coming up with something that just doesn't exist whatsoever, or being really inaccurate on a point.
So it kind of reminds me, for those who have children, kind of like when you're talking to your 5-year-old about what did you do today, or tell me about the movie or something that you just saw, and they just totally fabricate something that possibly could not be right. I think my son one time said that he went hunting with my dad and they killed a bear. And I was like, you're 5, first of all. Why would your people take you hunting? And where would you have possibly killed a bear? But it's adorable, right? So I really do enjoy those posts and those, rulings, because it's amazing what AI comes up with. It's very creative.
Yeah. Well, I think that, the problem with hallucinated citations and legal authorities in this context, especially the legal context, is you gave the example of the 5-year-old, right? If the 5-year-old tells you a story, a tall tale that, they went hunting and killed a bear, you immediately detect that they are not being accurate, right? Because a 5-year-old is not going to be able to hunt a bear. Like, and so it just stands to reason. It's not very plausible. And the difference between these 5-year-olds that we're talking about who are making things up and have a fantastic imagination and the outputs from large language models is that the LLMs are putting out very plausible, convincing,
Yeah.
and confident wrong things. And so if you're not a
It's
legal
very confident.
practitioner, yeah, or even if you are a legal practitioner, we're seeing lots of lawyers being sanctioned in other courts. You can be fooled because we're not used to seeing things that are so wrong look so right.
Hmm. Yeah. Deep fakes, which I've been, questioning website links and Google results and things like that for decades. And so, I think in industry we have this funny laugh off thing. Well, if it's on the internet, it must be true, right? Well, if anything, in the age of AI, if it's on the internet, it most likely is not true. And so I'm to the point where I don't trust almost anything that I read or I get anymore. So it's in one vein, all this new technology has been great because it kind of frees you up to do critical thinking
Mm-hmm.
and to question the why, the how, the, so what. But at the same time, it also has increased my workload in that now I have to not only double check, but sometimes triple and quadruple check just because I'm like, yeah, that kind of sounds right. And it's
Mm-hmm.
just a little spun where if your spidey senses go up and you're like, wait a second, that doesn't seem quite right. You're probably onto something and now you need to check it. So it becomes quite a chore now to even validate content out there. So let's move to our next segment, which is called Stall Termination Settlement Proposals.
Yeah.
And this is something that I'm not super familiar with, but you recently wrote it in the NCMA's contract management magazine about delays in resolving TSPSs. And so, can you walk us through what's happening when agencies kind of drag their feet and how contractors can use strategies like impasse to push for resolution?
Yeah. NCMA published a recent piece that I wrote about really the problems with all these canceled contracts from the beginning of the year. Most of them are going through this process, which I'm sure your audience is very familiar with, which is a termination for convenience of the government, right? A T for C. And a T for C is distinct from a termination for default, where a termination for default is the contractor did something wrong. You know, they took too long, they delivered the wrong services, and it's a much more severe sanction. Termination for convenience is just the government gets to be, the sovereign state that it is, and say, yeah, we just don't want to pay you anymore beyond whatever costs we've already incurred. A lot of times, these follow a stop work order or a suspension of work, where the contractor is told, stop what you're doing and try and wind down the costs related to this project. And then we'll later get this termination for convenience, telling them that they've got to wrap up. And in those situations, contractors submit what's called a termination settlement proposal to the agency. And I referred to this earlier. The new administration has really taken a chisel to the federal government, especially the agencies, a lot of specific agencies, but generally just cuts across the board. And so even before all of these cuts, which severely, reduced the personnel, maybe the contracting officer that you had on your project is reassigned, quit, was riffed. And then somebody else who's unfamiliar with the project, it lands on their desk, and it's sort of the termination settlement proposal goes further and further down in their list of priorities. And a lot of times they end up in this sort of purgatory of they know that they're entitled to these costs related to finalizing the contract and winding down the contract, but they don't know when the agency is going to pay them. And that's a very frustrating situation for contractors to
Horrible.
be in. And they often feel very frustrated that they don't have a path forward. So my article really talks about this concept called impasse, which typically is done in the context of negotiation. So everyone should be pretty familiar with the distinction between a request for equitable adjustment and a certified claim. So those two are distinct because when you're in the REA stage, you're still negotiating with the government. Maybe you'll chip off some portion so that the government will concede, and then you'll reach an agreement and you'll get paid. With a certified claim, you say, these are my costs and we're done negotiating, and give me a final decision. And then we'll move to litigation if we have to, if the final decision isn't what we like. So the impasse process is very similar to that. And to put it simply, you're asking for a final decision on the termination settlement proposal. And then if they don't respond, at least you have a path forward, because no matter what, the agency can't stall forever. There's a statutory requirement that they render a final decision within 60 days, or you can appeal what's called a deemed denial of your claim directly to the Court of Federal Claims or the boards of contract appeals.
Yeah, it really sounds like not only is the government having challenges, but then also contractors and consultants too, because I feel like this year is such a twilight zone kind of year for both government and industry. And the bad habits or the unfortunate activities at the top, at the federal level, have trickled down to the contractor and now is trickling down to the consultants, where consultants are also experiencing some of the same challenges. And so we're kind of going through some of the, we did this, now you're terminating, or you're just choosing not to pay for whatever apparent whimsical reason. But when it comes down to on paper, contractually speaking, you asked, we supported, we provided. This is, like, would you go to Costco and say, oh, I'm sorry, but I've got $500 worth of groceries. I'm only going to pay you, like half of it, or I'm not going to pay you at all because I need it, right? Like you wouldn't treat a normal business like that. But in consulting and in GovCon, it seems like anything will go at this point. So this is like a really unfortunate situation, but it's nice to know that there's a process for how to get some type of resolution, but it's going to take some time.
Yeah, it'll take some time. But often what we see is that once we ask for the final decision, the government gets its act together. They find, the audit of the termination settlement proposal, and they pay you out. And guess what? If not, we're talking about litigation, yes, but because you can go to the Court of Federal Claims, and now this is a claim, not a bid protest, right? So you
Right.
have the choice between two forums, depending on which sort of agency you're with. You can go to the Armed Services Board or the Civilian Board, and then the Court of Federal Claims also has jurisdiction over these claims, these disputes about money under the Tucker Act. And as opposed to like a different, like highly contested claim, most of the time the termination settlement proposals are relatively simple. They're often audited already by a third party or the government. So there's not really a dispute as to the entitlement, as to whether the contractor actually deserves the funds that are at issue. And so if you take it, and this is the recommendation I give in my article, if you take it to the Court of Federal Claims, what's unique there are two things. One is that the litigation will be taken over by a Department of Justice attorney who will have ultimate ability to settle the case, even over the objections of the agency. So maybe things have gotten contentious with the agency, and they, or maybe the people who are familiar with your project aren't anymore working with the federal government. In any case, the Department of Justice can settle on the agency's behalf. And not only that, but they can do it out of what's called the judgment fund, which is an independent pot of money that the government has to dole out for settlements and claims. And importantly, if the agency has run out of money in its budget, that could be part of the reason that they're not paying your termination settlement proposal. Maybe they're waiting until the next fiscal year or something. But the judgment fund is available now, and the agency, doesn't have control over the judgment fund. And so the Department of Justice can just say, yeah, we think there's entitlement here, and we're going to pay the contractor. And then you don't even have to litigate any further. So I think it's a pretty good, clean process, all things considered.
That sounds really good. And can the contractor recover like legal fees or any type of loss?
Yeah, it depends. For a request for equitable adjustments, you can include your legal fees to a certain extent. But once you get into the litigation process, the certified claims, and then filing a complaint, those costs are forfeited. Now you do get compensated with interest, Competition and Contracting Act interest from the date that you file your certified claim or your request for a final decision. And so there are some other ways to get funds that help you with the pain and suffering of the time that you've lost trying to get the dollars back.
Yeah, no, exactly. Well, that's good to know. So let's we're going to wrap up our episode here with our last segment, which I really like, is shifting standards, pleading rules and losers pays. So we're going to close out this protest process itself. Like GAO's pleading standards are tightening, and there's some debate around losers pay. And so what would these changes mean for contractors, especially small businesses? And do you think that they make the system fairer or harder?
Yeah, so every year it seems like there's a new debate about a couple of things, and usually it has to do with like one fundamental question: are protests good or bad? And a lot of people out there, I think it's popular to say they're bad, that they slow down the process, and it's easy to understand why people think that, especially because most of the time, if you're complaining about a protest, you're the apparent awardee, or you're the agency, and you're frustrated with the fact that the litigation is slowing down the project itself. And that's fair, and I understand the complaint. So every year there's usually a discussion about whether there should be additional rules, maybe make it harder to file bid protests, or they've got this thing called the loser pays concept, where if you've brought a protest and you lose it, then there are some additional penalties, either a statutory penalty, or you might be liable for compensating the agency for its legal costs, or the awardee for its costs, in lost profits, for instance. So there are always legislative proposals bouncing around discussing these issues. GAO put out a report in response to one of these legislative proposals in July this year. And they basically said, they addressed the two issues. They said, we don't think our pleading standard needs to get materially tougher, but they did make some nominal changes to it. We've seen the new standard in some cases, and to my eye so far, it hasn't really been a wholesale change. They just changed some wording and reconcile it with some of their previous precedent. So I don't think that is a big issue. But they did say something that I happen to agree with on the subject of loser pays, which is they said, you need to take a step back it's very frustrating if you are on a procurement that's protested and things are delayed. I understand that. But the number of protests has stayed steady over the last 10 years. I think it was around 1,700 at GAO. It's far fewer at the Court of Federal Claims. The agencies don't typically publish, comprehensive numbers about agency level protests, but there's no reason to think that they're increasing or getting worse. So what GAO said in response to that is there's less than 1% of protests that are happening on procurements, generally speaking. So, for every 100 protests, there's every 100 projects, there's less than one protest. That's a pretty low rate. And the benefits that we're getting out of the protests from a systemic perspective are much greater than than people typically understand. And that's because when there are protests or even the threat of a protest, the agency makes more of an effort to ensure that they're following the rules correctly. And, as evidenced by GAO's corrective action and sustain rate of about 50% across the board compared to 50% of denials, there are problems with the procurements that are being protested. If they're taking corrective action, they're not doing it for no reason typically.
Yeah, no, and I think that's good, right? Everybody makes mistakes, everybody misinterprets things. And so we need to have a mechanism for being able to do that. So a lot of times a standard Q&A process during the solicitation phase is usually acceptable. But with the greening of the force and with the loss of a lot of the 1102s, I think it's going to be a challenge to kind of continue at this rate. So I'll be really curious to see what the statistics and metrics look like next year, coming out of this year, to see whether or not some of the technologies and the solutions with AI have helped in this process, or if some of the trends that some of our other colleagues are seeing is that the defense industrial base is decreasing and contracting, that smaller businesses are leaving, that there's a whole slew of things that I know that we've discussed in other Tanstwocents episodes with other guests, that there's a lot of industry landscape shifts and changes that have impacted a lot of different things, and it could potentially impact the protest and claims process too. So.
Yeah, I agree. I mean, I think the industry as a whole has really been rattled this year, but it isn't just this year. It's sort of a long trend of fewer entrants into the government contracts industry in general. And I think that's generally bad. We need to be encouraging, especially small businesses, to come in and try your hand in this area. And I think that making protests harder is not really the right approach here. And I think luckily GAO agrees with me. And so that's why they don't recommend instituting a loser pays penalty for contractors. So for the time being, things haven't changed. I'm sure this proposal will come around again in a year or two, and we'll discuss it again. But one point you made there, and it goes back to our discussion of AI misuse, is it's never been easier to file a bid protest as a person who's unrepresented by a lawyer than it is today. I mean, you can generate something that looks plausible and file it with just a $500 fee and ChatGPT. Now, should you do that? I'm biased, but I say no. And I would be worried about some sanctions coming down the line.
Yeah.
We've seen GAO previously sanction protesters and institute essentially what are called anti-filing injunctions against them. There was a case in 2016 at GAO called Latvian Connection, where the protester had filed 150 protests in a year.
It's like total
and they
abuse.
were all dismissed. And so GAO basically said, you need to come and get permission from us before you file any new protests. And similar things have happened at the Court of Federal Claims. And yeah, I think the rise of AI and the ease of protesting, especially at GAO and the agency, could cause a substantial uptick in the number of overall protests, and we'll see at the end of the year.
Yeah, we shall see. So let's wrap up this episode with some key takeaways from our discussion. First of all, your forum choice matters. So are you playing in Little League, the minor leagues, or the major leagues is really important. And obviously, the underlying sentiment is that AI is not a shortcut. It can help, but obviously it hallucinates, it misquotes. It's like a creative 5-year-old when it comes to writing your protest. But timeliness too. I think time is kind of one of those unforgiving things that we are challenged with, not only in our personal lives and our professional lives, but it's so much more important here when you're trying to file a protest. But then also, don't let the TSPs stall out. Know when to declare impasse and when to escalate, which I think was the biggest takeaway for me on this conversation. So I really appreciate you bringing some of these to light. David, some last parting thoughts here for our intellectuals before we close out.
Yeah, the stance that I'm taking on LLMs and AI, it seems harsh because I'm viewing it in this context where we're seeing real errors and the possibility for people to have serious legal repercussions from using it. But that's not to say that I think that it's useless. To the contrary, I'm the co-chair for Burr's AI committee, and I think that when used effectively and with an understanding of where it can go wrong, it can be very beneficial. And you highlighted one of the best ways to use it, which is you've already got an idea, and let's just change the tone or like improve the writing a little bit. But I think that it's when you're taking something and giving it very few inputs and letting it run wild
Yeah.
without verifying things at the end. That's when you really run into trouble.
Yeah. I think when I make t-shirts, I love swag. I think I'm going to make a t-shirt that says, don't let your 5-year-old AI write your bid protest.
I'll buy one. I'll be the
Okay,
first one.
there you go. Well, intellectuals, this concludes our episode here today on government contracting at a crossroads. Please subscribe to Tanstwocents and stay tuned for future episodes every other Wednesday. And David, thanks for joining us here today. I really appreciate our conversation.
Yeah, thank you so much for having me, Tan. It was really a great conversation, and I look forward to. I think I'm going to see you in November at another event, so that'll be great.
Yep. Tanwilson coming to a theater near you very soon. So, intellectuals, thanks again for listening here today. And remember, you have to think big to win big. Be an intellectual, and until next time, keep pushing the boundaries of possibilities.